To Donald Trump, he took the stand in the courtroom here in New York, got fined $10,000 for violating the judge's gag order in his civil fraud trial.
Donald Trump, and he added another one when he became the first president placed under oath and answered a judge's questions as a courtroom witness.
In the shadow of the White House, where power once flowed unchecked from the Oval Office, a single courtroom stands as the one place where Donald Trump's entire playbook collapses, where a judge's gavel echoes louder than any rally chant, and where the authority of the Supreme Court, senators, and Congress itself converges into a moment of raw constitutional reckoning that could redefine the limits of presidential power forever. Picture it. The former and current president of the United States, the man who dominated television screens, social media storms, and global headlines, stripped of every advantage he has ever wielded. No adoring crowd to cheer his defiance, no ability to pivot the narrative with a perfectly timed post or press conference walkout. Instead, he sits at the defense table under the unyielding gaze of a judge whose authority is absolute within those walls. The air is thick with tension, the kind that makes hearts race and cameras zoom in closer, capturing every flicker of frustration, every whispered consultation with lawyers who look increasingly strained. This is not the arena Trump built his empire in. This is the one place where rules are not suggestions, where evidence doesn't bend to charisma, and where defiance carries consequences that no political spin can erase. And right now, the trajectory of his legal battles is hurtling toward a confrontation so dramatic, so unprecedented, that it feels ripped from the pages of a political thriller, yet every step leading there is grounded in cold, documented court records. The contrast hits like a thunderclap. In every other environment Trump has mastered, the roaring rallies where thousands hang on his every word, the television interviews he can steer with bombast, the social media posts that ignite millions, even the White House press briefings where he set the terms, control belongs to him. He decides when to speak, what to unleash, when to exit the stage as the hero fighting the system. The audience, the message, the moment, all his. But step into a courtroom and that universe inverts. The judge controls the environment with iron precision. The evidence dictates the narrative, not sound bites or slogans. Officers of the court bound by oaths to the law, not to any political identity or public prominence, enforce the rules without favoritism. When a judge issues an instruction, compliance isn't optional. When a gag order lands, it binds. When contempt is found, sanctions follow, escalating until order is restored. And if warnings go unheeded, if defiance persists, the judge holds the ultimate tools: removal from the proceedings, continuation in the defendant's absence, or even physical detention to compel respect for the court's authority. This isn't abstract theory. It's the machinery of American justice, tested across centuries, now facing its most high-profile collision in modern history. Consider the weight of it: a man who survived impeachment trials, who navigated Congress with fierce alliances and bitter divisions, who shaped Supreme Court appointments that reshaped the legal landscape, now confronting the one room where none of those levers work. The drama unfolding isn't mere spectacle. It's a pressure cooker where political instincts clash with legal imperatives, building suspense with every ruling, every violation, every moment the tightrope frays. At the heart of this tension lies the New York hush money case, where Judge Juan Merchan's courtroom became the stage for a meticulously documented escalation. Merchan issued a gag order not as a blanket muzzle on political speech, but as a targeted shield. Trump could defend himself vigorously. He could critique the prosecution and the proceedings broadly. What he could not do was unleash public statements aimed at witnesses, jurors, court staff, or their immediate families, statements that could intimidate, endanger, or derail the process. The order was calibrated with care, recognizing the defendant's massive platform and the history of how his words could mobilize supporters to harass targets. It was about preserving the integrity of justice itself, not silencing a candidate. Yet the violations came. The first contempt finding brought a fine and a stern warning. The second, another. By the ninth, the pattern was undeniable. 9 separate findings, $9,000 in accumulated penalties. Each time, the judicial language grew sharper, the warnings more explicit. Financial sanctions mounted, but compliance did not follow. Instead, post continued, attacks tested the boundaries, the performance of defiance persisted for the base that demanded it. Merchan's words cut through the fog. Future violations could trigger not just bigger fines but incarceratory punishment, physical detention. This was no idle threat. It marked the point where the enforcement sequence shifted gears, where the judge signaled that the court's patience had limits, and that the next step involved custody to enforce compliance. The emotional intensity in that courtroom must have been electric. Reporters present described scenes of visible strain, Trump frozen as damaging evidence unfolded, urgent whispers with his legal team growing more tense amid adverse rulings, a posture shifting from initial contemptuous boredom to the rigid tension of a man processing the weight of accountability in real time. Early departures from related civil proceedings added to the record physical exits that judges noted as revealing an attitude toward court authority. Outside those walls, the fury amplified, social media broadsides peaking on the days when courtroom losses stung hardest, rally speeches scorching judges precisely when rulings hit deepest. It was a feedback loop of pressure, internal restraint demanded, external release craved, the two pulling in opposite directions with explosive force. This pattern wasn't born in isolation. It reflects a deeper truth about Trump's operational style meeting an immovable institution. In rallies or interviews, defiance fuels the narrative of the fighter against elites. It rallies supporters, generates energy, reinforces the image of a warrior unbowed. But in the courtroom, that same defiance violates orders, stacks contempt findings, erodes credibility with the judge evaluating not just facts but demeanor and respect for the process. The political value collides headlong with legal cost. The base demands the show of strength. The court demands order. Continuing the performance risks everything, yet stopping it feels politically suicidal. The result is a self-reinforcing escalation, documented step by step, pushing closer to the brink rather than retreating. To understand how real the endpoint feels, turn to the legal bedrock. The Supreme Court itself provided the framework in Illinois v. Allen, the 1970 landmark ruling. A defendant so disruptive that orderly proceedings become impossible can be removed, physically escorted out by court officers or federal marshals, and the trial continues without them. The constitutional right to face one's accusers and be present is profound, but not unlimited. It can be forfeited by one's own conduct. Repeated warnings ignored, disruptions persisting, presence turning from right to obstacle. These trigger the authority. Marshals don't negotiate or defer to status. They execute the judge's order, their loyalty to the court absolute. This power applies to every defendant, regardless of fame, fortune, or former title. No exception for presidents, no carve-out for political icons. The distance to that scenario isn't measured in years of appeals or political maneuvering. In the documented sequence, financial sanctions were exhausted. Incarceration was named as the active consideration. One more violation and the mechanism activates. It's not fantasy. It's the logical next page in a chapter already written in court transcripts, fines paid, warnings issued. Legal experts across analysis confirm the dynamics, the trajectory is real, the endpoint explicitly flagged by the judge. Viral dramatizations, even when labeled fictional, capture a collective awareness that this path leads somewhere historic, unprecedented in American political life. Yet the story deepens with the complexities of a sitting president entangled in such proceedings. Constitutional questions swirl like storm clouds. Can a president in office face physical contempt enforcement, removal by marshals from his own trial, brief detention to compel compliance? No Supreme Court precedent directly resolves this, because no prior occupant of the White House has tested these waters. Protections exist, immunity in certain official acts as clarified in rulings, but they do not grant a blanket license to defy core court orders. Civil contempt, aimed at securing compliance rather than pure punishment, operates on principles that pierce easier through executive shields. The foundational citizen Trump logic from appellate courts that even presidents answer to the law looms large. Enforcement would spark an unprecedented confrontation, with judges navigating uncharted territory backed by the full weight of judicial authority. Uncertainty here isn't a shield, it's jeopardy itself, a high-stakes gamble no leader should invite. Zoom out further, and the hush money contempt fits into a broader judicial awakening. Across jurisdictions, courts have pushed back against tactics perceived as abusing the system. Federal sanctions in Michigan against lawyers filing suits on fantastical claims, guilty pleas in Georgia from attorneys admitting roles in alleged criminal schemes, bar disciplinary actions targeting professional misconduct, unanimous appellate rulings affirming former presidents' subjection to criminal law, injunctions highlighting patterns resembling overreach, Supreme Court decisions striking down expansive executive claims. Individually, each addresses a narrow issue. Collectively, they signal a system no longer willing to accommodate endless delays or process weaponization. The judiciary is protecting its integrity, applying tools long available but now deployed with resolve. In Trump's case, this lands most personally, contempt not just against lawyers or policies but the man himself. The behavioral documentation from inside the courtrooms adds haunting layers. Reporters chronicled the shifts, the initial swagger projecting that these proceedings were beneath him, the visible tensing when evidence cut deep, the fixed stares and hurried consultations as losses mounted, departures that spoke volumes. The correlation was telling. Worst days inside fueled fiercest attacks outside. It painted a portrait of immense psychological pressure, a figure accustomed to dominating every space now confined to one where his tools, charisma, diversion, crowd energy were neutralized. Whispers of tension with counsel, the weight settling visibly, the struggle to maintain composure under scrutiny no spin could soften. This wasn't weakness on display so much as the human cost of institutional gravity asserting itself, the one environment immune to the performance that defined his career. Emotionally, the stakes couldn't be higher. For supporters, any enforcement evokes fears of persecution, a system rigged against their champion. For critics, it's validation of accountability, proof that no one is above the law. The nation watches, divided yet transfixed, as constitutional principles clash with political reality. Senators debate implications on the floor, Congress weighs oversight, the Supreme Court hovers in the background of precedent and potential review. The White House itself becomes a pressure point. How does a sitting president balance duties with legal peril? The drama unfolds in real time, each hearing building suspense, each ruling a plot twist in a saga that tests the republic's foundations. Imagine the scene if the endpoint arrives, marshals approaching the defense table, the judge's order clear, the president escorted out as proceedings continue. The image would sear into history, the strongman, the untouchable figure removed from a room he couldn't command. Not through force of arms or coup, but through the quiet authority of the law. Officers unmoved by titles executing duty. It would shatter the always wins aura, providing visceral proof of the citizen principle, subject to the same rules, the same limits. For accountability narratives, impeachment echoes, fitness debates, removal calls, it would be indelible visual ammunition, more powerful than any transcript or filing. The political damage to the invincibility brand, immediate, perhaps irreversible. Every argument about fitness amplified by footage no edit could soften, yet the trajectory persists. Documented violations without self-correction, fines insufficient, warnings unheeded. The incompatibility remains. Political survival demands defiance, legal survival demands restraint. As pressure compounds, escalation follows. The endpoint sits one violation away, not some distant hypothetical. Courts have named it, records confirm the path. And in that gap lies the suspense gripping the country. Will compliance come, or will the unimaginable unfold? This courtroom crucible reveals deeper truths about power in America. The founders designed institutions to check ambition, to ensure even the highest office yields to law. Trump's journey through these halls tests that design like never before. The emotional toll on all involved, judges guarding fairness amid threats, staff fearing harassment, a defendant navigating unprecedented scrutiny, humanizes the constitutional drama. It's not dry procedure, it's lives, legacies, and the nation's soul hanging in balance. As proceedings evolve, the interplay of factors grows only more intricate. Legal teams craft arguments around immunity and scheduling, seeking delays or dismissals. Prosecutors press for adherence, emphasizing the harm of unchecked statements. Judges balance rights with order, crafting orders that withstand appeal while protecting participants. Reporters capture nuances cameras miss, a clenched jaw here, a heavy sigh there, the subtle erosion of the defiant facade. Public reaction amplifies everything, polls shifting with each headline, bases mobilizing, opponents framing it as comeuppance or overreach. Senators issue statements, Congress holds hearings on broader implications, the White House navigates optics and operations. The Supreme Court, having already shaped related doctrines, stands as the ultimate potential arbiter. Through it all, the core tension endures. The one room where the playbook fails exposes vulnerabilities no rally can mask. Defiance that thrills outside invites sanctions inside. Performance that unites a coalition risks isolating the defendant from justice's norms. The suspense builds relentlessly. Each new post, each hearing, edges closer to the flashpoint. Will the pattern break, Or will the judge's authority prevail in the most visible way possible? The broader significance ripples outward. It challenges the strongman archetype central to modern populism, the leader who bends institutions rather than yields to them. A removal would affirm that courts remain the great equalizer, that titles confer no exemption from basic decorum. It would fuel debates on presidential fitness, echoing through impeachment discourse and 25th Amendment invocations. For the public, it crystallizes abstract principles, rule of law not as slogan but lived reality. Emotional responses would flood the airwaves, outrage, vindication, confusion, as the nation processes a visual it has never seen. Legal scholars pore over precedents, debating how enforcement against a sitting president might unfold logistically, coordination with Secret Service, impacts on executive functions. Yet the principle holds, the court's contempt power exists to prevent chaos, to ensure trials proceed. No defendant, however prominent, can hold justice hostage through persistence. The documented 9 findings, the fines, the explicit warning, they form a chain leading to one conclusion if unbroken. In the cinematic sweep of this story, every element heightens the stakes. The marble halls of justice, the somber robes, the murmur of onlookers, the flash of cameras outside. Inside, a battle not of armies but of wills, one man's instinct to dominate versus an institution's duty to restrain. The emotional core, frustration mounting, isolation in a crowded room, the slow realization that some arenas resist conquest, touches on universal themes of hubris and humility before the law. Transitions between phases feel seamless yet charged. From gag order issuance to first violation, the warnings land like warning shots. Fines accumulate, each insufficient, building judicial frustration palpable in transcripts. The shift to incarceration language marks a threshold crossed, the sequence now pointed inexorably forward. Behavioral observations interweave, humanizing the legal arc, not just numbers, but a person under duress, tools failing him. Political calculations clash with reality, the base's expectations a gravitational pull toward further risk. Enforcement complexities for a president add layers of national anxiety, the unprecedented nature fueling speculation and dread. Broader judicial patterns contextualize it as no anomaly but a symptom of systemic resolve. Courts saying enough, enough to frivolous filings, enough to evasion, enough to threats against process. The hush money case personalizes it, the defendant himself facing the sharpened edge. Political ramifications echo through elections, governance, public trust. An image of removal wouldn't just end a hearing, it would punctuate an era, visual shorthand for limits enforced. The narrative presses onward, dynamic and unyielding. With each passing development, the distance shrinks, violations haven't ceased, the pattern holds. Self-correction remains elusive. The endpoint hovers, named and authorized, a constitutional sword of Damocles. The country, divided yet united in fascination, awaits the next chapter in this high-stakes drama, where democracy's guardrails are tested in the most public forum imaginable. What unfolds next will resonate far beyond any single verdict. It will speak to the endurance of institutions forged in revolution, designed to outlast any one leader, to the resilience of a republic, where even presidents confront the impartiality of justice, to the emotional fabric of a polarized nation grappling with power's boundaries. In that courtroom, where Trump's playbook stops, America confronts its foundational promise: equal under law, accountable always, dominant forces yielding to deliberate process.